Welcome back to Fort Worth Accident Attorney and Law with Aaron Siddique. I'm Abby, and today I'm here with Aaron Siddique from 1-800 The Wolf Accident Attorneys. Good to have you back, Aaron. Thanks for being here today.
Hey, Abby, great to see you again.
So, if you ride in Fort Worth, three things quietly decide your case before you ever talk to a lawyer. The first is the Texas helmet law and the way the insurance company treats a legal decision you were entitled to make. The second is on I-35 West, the Mixmaster and the NTE construction zones, and the way drivers fail to see motorcycles in lane geometry that wasn't designed for two-wheel traffic. The third is the rider bias problem in a Tarrant County jury venue that documented research treats as conservative on personal responsibility. This episode walks through all three. So, getting into question one, most people assume a wreck is a wreck, but a motorcycle case in Tarrant County runs a different playbook from start to finish. What makes a Fort Worth motorcycle accident case different from a Tarrant County car accident case?
Motorcycle accidents are severe, oftentimes traumatic, and the injuries and damages usually exceed the policy limits available. So it's really critical to get a jump on these things and hire an attorney that understands the playbook that you are referencing. Not two law firms run the same playbook, but there's a handful of things, I'd say 4 or 5, that really make these different from a standard car accident and make them different from a trucking accident. And I'll jump into that. So I touched on it. First of all, rider exposure. Every motorcyclist knows this and is aware, and every bicyclist knows this. If you've crashed your bicycle, if you haven't ridden a motorcycle, but rider exposure, first and foremost, the rider of a motorcycle is going to absorb the energy of a crash directly. Okay. There's nothing in between the rider other than maybe the front tire and the vehicle that hits that rider. The injuries are typically severe. The medical billing just runs higher than the comparable car wreck. You have nothing to protect you other than your helmet and your jacket. So rider exposure is number one. Rider bias. So I want to explain what that means. There is a rider bias baseline, particularly in Tarrant County. Okay, so we practice all over Texas, but our home base is Tarrant County, and we inherently understand how the jury pool thinks here. And Tarrant County juries are statistically conservative when it comes to personal responsibility. Okay. This is the land of take ownership. And so there is a biker stereotype that shows up, particularly when we're in voir dire or the jury selection process. Whether anyone actually comes out and says that or not, there's an underlying bias that, hey, you were riding the motorcycle, you assume the risk, or that you were partially responsible. Third thing, it's a big one. Helmet defense exposure. Insurance companies love to introduce the helmet question on the very first call. So whether it's your own insurance company, and I said this here before, be careful when you talk to them as well, or the person who hits you's insurance company, if you're lucky enough to have survived the crash and your injuries aren't so severe that you can actually talk to them. But they're going to bring that up on the first call. They're going to ask you if you were wearing a helmet or not. And regardless of whether the rider was wearing a helmet or whether the Texas Transportation Code, specifically 661.003, if I recall correctly, requires it, they're going to ask about it. And they're going to raise that as a part of their defense. And then this entire kind of difference between car accident and motorcycle accident, there's a really different evidentiary or evidence playbook. TxDOT, the CRIS system, it's where all the crash data is reported. The Fort Worth PD CR3 form report accident reconstruction experts. Helmet cam or GoPro, a lot of riders are wearing these days to protect themselves or just to film themselves going fast. All of these things carry more weight than they would in a routine car accident case. And then venue mechanisms. And when I say that, the place where we would have your case heard. So Tarrant County District Court, particularly the juries there, are more conservative, particularly in motorcycle cases. And their verdict and awards typically run lower than a comparable car accident case, unless you have a good attorney that addresses the bias I talked about earlier pre-trial. And we here at 1-800 The Wolf Accident Attorneys are experts in doing just that.
And that rider bias usually does not announce itself. It shows up in the jury room after the testimony is done. So what is rider bias, and how does a Tarrant County jury quietly hand the insurance company a win?
It's a combination of things. And so I touched on it earlier. There's a documented venue baseline. We can tell there's different jury awards for car accidents versus motorcycle accidents in conservative versus more liberal counties, particularly in Tarrant County. There is a motorcycle rider biased in Tarrant County in terms of jury venue, and it sits right at the top of a documented conservative jury tendency around specifically personal responsibility. Tarrant County juries are big on that. And so there's just something about getting on a motorcycle that I think signals to conservative juries that you assumed the risk. So that kind of flows into the next point, which is just the stereotypical shorthand. So jurors will substitute, hey, this biker chose the risk for a proper negligence analysis. They're almost going to forget about the fact that the driver that hit you owed you a duty to drive in a safe and careful manner and struck you. And they're going to say, well, you were on the road, you didn't have a helmet on, you were zooming, you were changing lanes. So, and that's when we would see the Texas proportionate responsibility rule kick in. If someone is found to be 51% liable in an accident, and that's close to 50-50, but if they were found 51% liable, they're not going to recover. That's kind of the insurance company's leverage. The insurance adjusters know, just like we know what a venue, what their tendencies are. They know if there's a conservative jury pool. We've had them say that to us. Do you really want to go try a case out here in McClellan County? It's conservative. Our answer every time is yes. We're 100% confident in what we do, just based on what we're discussing. We're armed with this knowledge just like they are, and I don't think they use it as effectively as us. But yeah, the insurers do definitely know the venue's tendency, and they'll structure a recorded statement. If you give a recorded statement to an insurance adjuster in Tarrant County, they have already tailored that recorded statement's questions to the venue that you're in to trigger jury bias if it ever goes there. They'll ask you the helmet question. They'll ask you questions about lane position to try to bait you into saying something that could get a jury to consider the rider's fault percentage was past 51%. And that's a fine line to be walking when all of this money and all of your pain and all of your suffering and all of your injuries are on the line. Jury selection, voir dire, that's kind of the cure. So the bias that I'm talking about in conservative jury pools, particularly in Tarrant County, it is addressable in pretrial, specifically through jury screening questions. Not everyone is biased, but if you understand historically what's happened in these venues and your counsel, your attorney addresses it appropriately before the trial starts, you've already mitigated that damage. And so that kind of leads into pretrial education, right? In the trial itself, if you haven't addressed these things, you've almost certainly lost. But we're going to bring in things like expert testimony, and we're going to re-anchor this case and bring the jury. We lead them to water and let them focus on the at-fault driver's negligence and failure to see things rather than the conspicuousness of what a defense attorney would try to raise.
That helmet law gets cited constantly, and most writers cannot tell you what it actually requires. So, what does Texas helmet law actually say, and where did the Texas Transportation Code 661003 come from?
The section 661.003 contains a couple of different provisions. I'll get to that first. Most importantly, protect the kids. You're not really a kid anymore if you're riding a motorcycle, but there is an under 21 rule. So Texas Transportation Code 661.003 does require a Department of Transportation, or DOT, you'll hear me refer to it as that, compliant helmet certified to a specific standard. The standard is FMVSS 218 for any rider or any passenger under 21. Then there's a 21 and over exemption. So adults 21 plus may ride helmetless, okay, if they meet one of two prongs under this code. You can complete a MSF basic rider course from a Texas-approved provider, or you can provide proof of at least $10,000 in medical or health coverage for crash injuries. What does that tell you? They are concerned that you either have the training, or if you don't have the training, you have at least some policy in place to take care of the injuries that they're already anticipating. That's how crazy this stuff is. Now, the enforcement reality of this is the Texas DPS and the Fort Worth Police Department, these officers, they can't stop a rider solely to check helmet status under the same statute. Hey, adult not wearing a helmet, did you take the course or do you have the proof? The helmet violation is really only chargeable when they've stopped you for some other lawful basis, unsafe lane change, speeding, using your blinker. But just so you know, if you ride without a helmet, They may target you anyway. It happens all the time. It's called a pretext stop. Not sure you can prove it, but if you didn't do anything wrong, they're going to say you did if they want to find out anyway. So it's better to just comply with the statute. MSF certification, what is that? You got to keep the completion card with you in your wallet or in your saddlebag. So I referenced the MSF certification, that you actually get a card when you get that certification. So you should keep that MSF basic rider certification completion course card in your wallet or your saddlebag. It does neutralize the helmet violation citation at the scene if they were to stop you from something else lawful. And then in addition to that, insurance documentation, you got to do this in a car, you got to do this in a motorcycle, but keep proof if you're going to ride without a helmet under that 21 and over exemption. Keep proof of the $10,000 plus and medical coverage with the bike registration, because an insurer is going to ask for it, a police officer is going to ask for it. It'll come up even before the helmet defense comes up. So insurance companies will use this against you just like the police will if they're going to cite you.
And then this is the part that catches every adult rider off guard, and the case law underneath it is the whole game. If a Texas adult is legally allowed to ride helmetless, why does the insurance company still cut the settlement in half?
Well, this is an interesting one. So just because something in a criminal context doesn't mean that it's not going to cause you problems in a civil context. So I'll give by way of a criminal law example real quick, and then I'll get into the specifics. O.J. Simpson was famously acquitted of murder. And then in the civil trial, he was actually found liable for the murders. And so there are two different standards at play there. So in a criminal context or a moving violation or violation of a transportation code, totally could be non-applicable. But when it comes to a car accident where you have civil suits, it could absolutely kick in. So that is all to say that the helmet defense is separate from the helmet law. The helmet defense is a damages reduction argument under Texas case law. It's not a statutory bar. So it survives even when the rider was 100% following the law and choosing not to wear a helmet. And so it really goes back to what we call mitigation of damages principle under the Texas proportionate responsibility that we talked about earlier. So you do have a duty to mitigate your damages. A defense, they're entitled to rely on that. You could have, but you didn't. So a jury can consider it. Just because it's lawful, the jury can consider what impact it had in contributing to the worsening of your injuries. Head and neck restrictions. The defense only reduces damages casually tied to the absence of a helmet, like head, brain, neck. They're never going to bring that up to try to mitigate that, hey, you weren't wearing a helmet, so you broke your leg, or you got road rash, or you had damage to your internal organs, or your lost wages mostly, or just blanket fault on the case. It'll come up in a very specific context as it relates to the head and neck, because that's what the helmet is designed to protect. And then there's a causation burden. So the insurer will have to produce medical or accident reconstruction expert testimony tying that specific injury to the absence of a helmet. So it's not a slam dunk, but you just have to recognize that it's there. And so it's not really a generic safety argument, but it has some specific nuances in it. And then it's always like a reflexive insurance move, so to speak. The insurance adjuster is going to introduce the helmet defense in the first 48 hours on every adult rider claim. It's going to come up. So even when the rider has zero head injuries, the goal is to anchor the rider's fault and to the percentage of fault early. So if you remember, I mentioned the 51% rule. Any little thing that they can do to start convincing a jury, even though there's no jury involved at this point, that you might be 51% at fault for some of those injuries, they're going to do. And then there's something called rebuttal evidence. So the rider's MSF, basic rider, this is a mouthful, but basic rider course certification, the $10,000 we talked about and medical coverage on file, impact vector analysis from accident reconstruction experts. And then if the rider, if you're in this accident, you've gone to JPS, which is our level 1 trauma center, or even Texas Health treating physician, their records will all reduce or eliminate the defense's value. Okay, so every piece of that plays a vital part on both sides.
So the helmet law allows the choice. The helmet defense punishes the choice anyway. And the rider bias problem amplifies all of it inside Tarrant County. That sets up everything else. Next up, we're going to get more into the 51% bar and how insurers structure every motorcycle case around it. So the 51% bar is the single rule that decides whether the rider recovers anything or walks away with nothing. Does Texas's 51% bar destroy motorcycle cases? And what does Texas Civil Practices and Remedy Code Chapter 33 mean for a Fort Worth rider?
This is a great question because I think a lot of not just drivers, but riders are not aware of this. They think, okay, I was in an accident. It was that guy's fault. But was it all the way his fault? 100% liability is different than 51% liability or 30% liability. Talked about it before on here, but Texas has a modified comparative negligence scheme. So Texas proportionate responsibility under, you said the Texas Civil Practices and Remedies Code. I'm going to abbreviate that as the TCPR. That's what attorneys say. Chapter 33, it will reduce recovery by whatever amount that was apportioned to the rider's fault percentage. Okay. If you're 51% at fault, you're barred. So naturally, this is the dial that the insurer will turn. Every motorcycle defense case is structured to push a rider past 51% by stacking allegations against the rider. Okay. They're going to bring up the helmet. They're always going to talk about speed. They're going to talk about lane position. They're going to talk about conspicuousness. Was the rider visible to the driver? Perceived recklessness. What's safe on a motorcycle? And if you know as a motorcycle rider, this is safe, this is normal, natural riding behavior, the insurance company is going to turn it into something different because there are fewer motorcycles on the road than there are cars. They're going to try to single you out and ostracize you. And it's just reduction math. If you were found 30% at fault as a driver on a $200,000 case, that is going to reduce your damages award by 30%, or in this case, $60,000. The rider's going to take home $140,000. But if you were found 51% at fault, it's not going to be reduced by 51%. It's going to be eliminated altogether. The driver would take home zero. So what does that mean? A lot of things for us. It means you got to hire a good lawyer. You got to call 1-800-THE-WOLF accident attorneys. You got to get the Wolf of Law Street on your side because we know what we're doing. But jury allocation. In Tarrant County District Court, the jury is going to assign fault percentages on a verdict form. They're going to be asked what percentage fault was the plaintiff and what percentage fault was the defendant. What you want to hear is the defendant was 100% at fault. But Voir, I talked about this, jury selection in the beginning, and the motorcycle rider bias problem decides where those percentages are going to land. And that battle is fought and won early on from an experienced attorney. So the leverage point, what's the leverage point? An attorney who refuses early in settlement and walks the case through accident reconstruction, conspicuity evidence, treating physician testimony that pulls the rider's number down. Okay, that's it. From day one, we're trying to mitigate what's going on here.
The adjuster does the same four things on every single Texas motorcycle case, and they are predictable, but they are also reversible if you know them. So, what is the four-step playbook every Texas insurance adjuster runs to blame the rider?
Abby, I wish it was a Texas two-step, but it's definitely a Texas four-step. They are tricky, and it is a dance. I'll tell you that. So what do? We hit them with the Uno reverse card. You can't beat an Uno reverse card, right? But seriously, their playbook does run around basically the same four steps. They're going to hit you first. The first step is the recorded statement. It is a landmine. It is a field full of landmines. You should never walk through it by yourself. But number one, the adjuster is going to ask for a recorded statement in the first 48 hours. And then that's going to lead the rider into making admissions about speed, lane position, and helmet status that they otherwise were not required to give. And it will lock in a version of events that is only going to serve to make it more difficult later. Step two, which we touched on, but it's always the helmet question. So even before the injuries are documented, the adjuster's asking about the helmet. They're setting up a helmet defense and that damage reduction or that dial that pushes your percentage of fault up over 51%. Helmet question. And then there's always the good old-fashioned lane position bait. The adjuster will ask every time where the bike was in the lane, fishing for any framing that could support, like, hey, there was a lane splitting allegation or you were traveling between vehicles. And they do that under Texas Transportation Code 545.060. And that's just a common tactic. They're going to try to lock you into a version of events and trip you up and talk to you about lane positioning. And then the fourth, this one is classic, the early low ball. Within 7 to 14 days of the crash, before anybody's reached maximum medical improvement, which is you're not going to get better, you're not going to get worse, and before the rider has opportunity to consult with counsel, they don't want you talking to us, particularly me. They're going to send an offer to resolve the case for a fraction of its value. And if you haven't consulted with an attorney, you don't know what the value of the case is. And so how do you mitigate this when you haven't hired a lawyer yet and they start running that Texas 4-step on you? Decline the recorded statement. They're trained to make you feel like they're your friend. You can tell them no, decline the recorded statement, refuse to discuss the helmet or lane position without counsel present, document for your own purposes, marked lane discipline at the scene with photographs, with your GoPro, with your helmet cam footage, and refuse any settlement before MMI. That's important. You have no idea. You could feel perfectly fine. You have no idea in the first 7 to 14 days if you have lasting or permanent injuries. Okay, that's just a fact. Contact a qualified attorney. If not me, should be me, but if not me, call someone else.
Then lane splitting is one of the most searched motorcycle questions in Texas, and the answer creates a trap most riders never see coming. Why does Texas's no lane splitting rule under Texas Transportation Code 545.060 still get used against a rider who never split a lane?
So that's the statutory rule, right? Our legislature has codified this in a way that makes it difficult for motorcycle riders. So Texas Transportation Code 545.060 requires every vehicle, okay, that means motorcycle or car, to operate within a single marked lane. Texas does not authorize lane splitting or lane filtering at any speed. You can't drive on the line. You can change lanes. And so a lot of times that's the allegation tactic there, right? The insurance adjuster is going to allege that the rider was crossing the lane line at the moment of impact, even when the rider was centered in the lane the whole time. And so it's easy to paint a motorcycle as lane splitting because they're so small. It's not as easy to do that with a vehicle. And why do those allegations stick? If you don't have photos of the scene, if you don't have GoPro footage, if we haven't hired an accident reconstruction expert in your case, it's literally the rider's word against the at-fault driver who has every reason to lie. I'm not calling everybody a liar, but obviously in this line of business, we come across them. And then you're facing an uphill battle. It's, hey, is my motorcycle rider as lovable and as cuddly as that little old man that ran into them in front of the jury? And when that jury's motorcycle rider biased defaults the wrong way towards the rider, how do we mitigate that? So the cure, fortunately, there's a cure. Marked lane discipline at the scene. Photograph of the bike's final position, okay, relative to the lane lines within the first 60 seconds. That's going to neutralize that tactic by the defense. And so we don't expect anybody after they've been in an accident to know this, but it's also good to get out there and document the scene. We do things like we'll do witness corroboration. So Fort Worth PD, CR3, the witness statements, and any nearby text dot or local traffic cameras footage are subpoena targets. In the first week, we make it a point in this office to request body cam and dash cam footage through Freedom of Information Act requests. We watch hours and hours of video on every accident, particularly these motorcycle accidents, pouring through what was the officer observing. So even if you missed it, we're going to go find it, and we're going to find it quickly, and we're going to preserve that evidence.
So the at-fault driver's defense is almost always the same single sentence. Conspicuity research turns that sentence into the rider's strongest evidence. So what is conspicuity, and why is it the writer's strongest counter to the "I never saw the motorcycle" excuse?
So the term is a term of art, but it's just easily described as motorcycle visibility, okay? Conspicuity or conspicuousness. It's the body of safety research on what makes a motorcycle visible to other drivers. And that could be headlight modulation, it could be high visibility gear, it could be lane position, time of day, it could even be things that you perceive. Loud exhaust, you hear motorcycles oftentimes louder than other vehicles. So what gives them their presence to other drivers? And a ton of research on this. So you have the National Highway Transportation Safety Administration, or the NHTSA, and then MSF research. Federal Motorcycle Safety Research treats, I didn't see them, as almost as a perception failure by the driver, okay? Not a hiding behavior by the rider. And that's the distinction, not a distinction without a difference. That's one that insurers will inadvertently try to hone in on. So it inverts the defense. The driver's negligence is the failure, okay, to keep the proper lookout. The Texas law requires that of all drivers, to see what's in plain sight, including motorcycles. And so sometimes you require conspicuity expert testimony or motorcycle visibility expert testimony, where an expert witness on motorcycle conspicuity reframes the trial, okay, around the driver's failure to look out and not the rider's bright vest choice, okay? Motorcycle riders are entitled to put whatever the hell shirt they want on. They can wear a helmet if they want to wear a helmet. I think they should, but if they don't want to, fine. But what the insurance companies and the defense will try to do is reframe it as that. You weren't visible. It was your fault. It's a form of victim blaming that, quite frankly, is quite frustrating. But an experienced attorney will flip that, and they'll hire the proper experts, and they'll reframe the case to give their clients and the motorcycle riders an advantage.
Fort Worth's freeway geometry was not designed with motorcycles in mind, and the conspicuity failure pattern shows up on the same stretches over and over. So, where on I-35 West and the Fort Worth Mixmaster does conspicuity fail the worst?
If you've been to DFW, if you're from Fort Worth or Dallas or have traveled in or through here, you already know the answer. The I-35 West and the I-30, Interstate 35 West and Interstate 30 interchange downtown. It's got overlapping decks. It's got short merge ramps. It's got aggressive lane changes. It creates a visibility environment that defeats even the brightest vest conspicuity attempt, okay? It is chaos. And so the NT express lanes as well, like the North Tarrant Express dynamic pricing express lanes on I-820 and I-35 run faster than the main lanes or the main lines. And the lane geometry, it's just insane. It shifts in road hazard construction footprints. It hides motorcycles and it puts motorcycle drivers blind spots. It's pretty wild. And I could go on and on. Like the I-30 corridor, the Fort Worth freeway system on I-30, the stretch east of downtown, it really carries heavy commuter and freight volume and runs through tight merges with limited shoulders. And so it's easy to get caught up as a vehicle driver and focusing on the vehicles around you and the hazards that have been created by all this chaos and traffic patterns and lose sight of a little small motorcycle. TxDOT, the IS system, the crash data system, identifies these segments as repeat motorcycle crash venues, and it's useful for our accident reconstruction experts. And then in pretrial use, like photographs, we'll use Google Street View documents for specific crash locations, and we'll layer in the TxDOT data over it for the jury, short of paying those tens of thousands of dollars for the expert, depending on the severity of the crash. There are some things that we can put together from public data, like that TxDOT data, like that Google Street View, that can be helpful for a jury.
If you map every Texas motorcycle crash, one pattern shows up more than all of the others combined. What is a left turn collision, and why is it the most common Texas motorcycle crash pattern?
Instead of making a right, I don't know why people make 4 left turns, but the pattern. So it's pretty simple. It's just like it sounds. A left turn collision happens when a car turns left across the path of an oncoming, say, motorcycle proceeding straight. Okay. And it's the most common car versus motorcycle crash type in the United States. The rider proceeding straight, and this is true for riders and drivers, but it happens more to motorcycle riders. The rider proceeding straight has the right of way under the Texas Transportation Code lane control rules. Okay. The turning driver, it's their duty to yield, particularly unless they have a solid green arrow, which 99% of the time they don't. And even if they did, they're not paying attention. So the driver's defense is always, I didn't see him. And the rider or our clients, we have to rebut that with motorcycle visibility and conspicuity evidence. And we have to highlight, again, we have to reframe the case, which we shouldn't. That's why it's an uphill battle. We have to reframe the case based on the at-fault driver's failure to look. And again, insurance companies love that 51% leverage. They're going to try to put fault onto the rider by alleging that every time the rider was speeding or they split the lane or anything they can do to get to that Texas proportionate 51% responsibility and kill your claim. We use these a lot, but an accident reconstruction specialist, and particularly in these types of cases, we use TxDOT CRIS data, Fort Worth PD CR3 witness statements, any traffic cam footage. It establishes speed, it establishes lane position objectively. Sometimes our riders are wearing certain things that you wouldn't even think would supply data, Apple Watches, things like that. So we really do a deep dive in gathering those things to help rebut what the defense is going to try to do.
The freeway pattern is one part of the story. The other part happens at low speed in the bar and dining corridors. How does Fort Worth dooring on Magnolia, West 7th, and Sundance Square fit into the conspicuity picture?
So you're down there and on West 7th, you're hanging out, you're partying. People are parked all along those streets, and so call those dooring zones, not finding Dory, dooring zones. Door collision crashes. You see it in the movies. It's freaking hilarious, but when it happens in real life, it's not funny. You open the door, someone hits it. But believe it or not, door collision crashes on Magnolia Avenue, West 7th Street, Sundance Square, and then even near the South Side corridor. They cluster around parking lines and the bar and dining traffic flow. So what's the standard? The duty under Texas law: the person opening a door has the duty to look. Failure to look is what we call negligence per se. It's separate from the at fault driver's framing. So, negligence per se means that there is a statute or a law or a rule and you violated it. It's not just basic negligence. But what we're looking at as well is injury severity inversion. Dooring crashes, they happen at usually 10 to 15 miles per hour, but they produce shoulder fractures, clavicle breaks, head injuries because the rider is typically thrown over the door. They can be quite severe. And then how does the conspicuity overlap come into play? The door openers, I didn't see them defense is the same defense as the left turning driver uses on the freeway or at an intersection. And guess what? We're going to need expert testimony to rebut both. So, and there's a witness layer, bar, restaurant, or retailer that operates the venue. A lot of time we'll have surveillance footage. We shoot out preservation of evidence letters as soon as you call us and we get the case within 24 to 72 hours. We have a case right now, major motorcycle accidents, severe injuries, traumatic brain injuries, and we were able to preserve evidence where the police accident report didn't necessarily line up with how the accident actually happened. And a nearby business had 3 different angles of a commercial truck running over our client, causing serious injuries on a motorcycle.
So we have covered the helmet law, the helmet defense, the 51% bar, the insurance adjuster's 4-step playbook, the lane splitting allegation trap, and the conspicuity backbone of every Fort Worth motorcycle case. Next up, what happens to the body, the bills, and the insurance coverage when one of these crashes lands a rider in JPS? The trauma docs at JPS see the same 3 injuries every weekend after a motorcycle crash on the freeway system. Why are Texas motorcycle injuries so severe, and what does JPS Hospital see every Fort Worth weekend?
That's a great question. The laws of physics. So there is obviously no protection. There's no protection physics on a motorcycle. The bike has no airbags. The bike has no crumple zone. The bike has no seatbelt. The rider absorbs all of the energy. Whereas in a car accident, that cage that's surrounding you, that is the vehicle, that is the car, it absorbs the energy. However, in a motorcycle accident, the body absorbs the energy directly, and that's quite traumatic. We see there's a commonality in these accidents. I hate to say it, a large number of the accidents that we've handled when it comes to motorcycle accidents have been deaths. And in the ones that didn't result in death, the 3 reoccurring injuries that we see primarily are traumatic brain injuries, severe road rash, and spinal cord injuries, plus long bone fractures to the tibia, femur, pelvis, and digits. So JPS as a level 1 trauma center. It's the only level 1 trauma center in Tarrant County, and it's the regional intake for life-threatening crash injuries. And then there's obviously care alternatives. So Texas Health Harris Methodist as a level 2 trauma center. We have Baylor Scott and White. We have All Saints. They all handle non-level 1 motorcycle trauma. Burn cases will route to Parkland Memorial Burn Center in Dallas. But there's plenty of care alternatives, but JPS or John Peter Smith Health Network is our level 1 trauma center. So how does this relate to your case or your case value? Injury severity obviously drives damages in Texas, including future medical costs, lost earning capacity, pain and suffering. The more complete of a medical record we have where you've received care from an actual qualified medical facility, it's a lot harder for the insurer to kind of discount that value. And they do. So you could have your leg broken in half and you could have a bill for $100. We're going to take it to the insurance company and they're going to say, that was too much. It's 50. Same injury. We could take them a $100,000 bill and I'd say that's too much. It's 50,000. It's all relative, but documenting properly makes it hard for the insurer to discount the value.
Brain injury is the single highest value injury in a motorcycle case, and it's also the easiest one for an insurance company to dismiss if the documentation is thin. So, what is a traumatic brain injury in a Fort Worth motorcycle case, and how is it documented at JPS or Texas Health Harris Methodist?
So anytime you've been injured, if you go to the doctors are going to run a physical assessment on you, and particularly in a car accident or a motorcycle accident case, they're going to start by diagnosing you with something called a Glasgow Coma Scale baseline and then neuroimaging. TBIs or traumatic brain injuries, they can range from concussion as a type of TBI all the way through the diagnosis of a severe TBI with permanent cognitive impairment. So again, they're going to run that Glasgow scale. They're going to run imaging, diagnostic imaging, typically within the first 24 to 72 hours. They're going to be looking for hemorrhaging, signs of trauma, but you're going to get an MRI or a CT scan at either JPS or Texas Health or one of the other providers, and that's going to help establish the injury. Gaps in imaging, 2-3 month gaps, really create daylight for defense attorneys at trial. Getting that imaging up front, if you have any of these types of symptoms, is wise because it helps dispel later that it was caused by something else. So you need a chain there to document it. And the symptoms to document, it doesn't have to be something crazy, okay? Something as simple as a headache is indicative of a TBI. More serious symptoms include memory loss, mood changes, light sensitivity, sleep disruption, learning disabilities, all need to be followed up on with a neuro evaluation, because TBI says symptoms like they can surface right away or they can surface weeks after the crash. So it's best to kind of make sure that baseline is being documented. And then when they start picking this apart, expert witnesses come into play. Accident reconstruction witnesses can tie impact vectors to brain injuries, and treating neurologists can also project future or lifetime costs, which are important to recover. Okay. You have to recover for the things that may happen in the future. That's part of your economic damages. If you don't recover them now and then you settle the case, something pops up later, you got a problem. And then the value range. People ask me all the time, what are these cases worth? I had a case that once upon a time where a girl received a mild TBI, and because it was only $2,500 in medical bills, we went to litigation. They were trying to settle the case for $2,000, $3,000, $5,000. The opposing counsel was like, "You're crazy." It ended up settling for a lot more than that. So these cases range anywhere from $100,000 all the way to multi-million dollars worth of damages and jury awards for severe and permanent injuries. And the trial value really is going to depend on the quality of the care you receive, the imaging, the cognitive testing, the documentation, the lifetime cost projection. We just had a case where we hired a neuro life care planner. So our client was on a motorcycle, received a severe TBI along with these other fractures and really severe injuries. And we didn't just hire an economist, we hired a neuro life care planner to document what is the cost and the value of this TBI over one's lifetime. Okay. So those things are important.
Yeah, the bills stack up fast, and the insurance coverage map is one of the most misunderstood pieces of any Texas motorcycle case. What insurance coverage actually pays after a Fort Worth motorcycle crash, given Texas's 30, 60, 25 minimums and the motorcycle coverage gap?
So first and foremost, this is for any accident, but particularly in these motorcycle accidents, the out-fault driver's insurance policy is going to be where we seek to recover. And in Texas, the minimum liability that our legislature has set forth that people must carry is $30,000 per person. That's Texas Transportation Code 601.072. Coverage gap. So Texas auto policies a lot of times will exclude motorcycles, like the rider's own auto policy may not cover a bike crash, even when the same insurer wrote both policies. Gap insurance is important there. And then motorcycle specific policies, a dedicated motorcycle policy with comprehensive uninsured or underinsured motorist coverage, stacking if applicable, which means if you have multiple vehicles, you can stack the limit for each vehicle. That's your first line of defense as an uninsured or an underinsured motorist that hits you. I will say, I tell my clients this, whether they ride a motorcycle or a vehicle, the more you or UIM you can afford, and it's not hundreds of dollars, it's like tens of dollars a month, the more you're protected. And so it may be $300 more a year, and maybe even after 10 years you haven't had an accident, but it's cost you $3,600, and then you have that accident, and that policy kicks in and pays you $100,000, you're going to be glad you had it. So if someone's carrying a $30,000 minimum policy and they hit you on a motorcycle, you better believe that's not anywhere close to what you need. I'd say looking at that coverage. And then personal injury protection benefits, which is PIP. In Texas, the minimum PIP that has to be offered to you is $2,500, but it's optional. Other states, this is mandatory, but I don't know why. Texas, it's optional. They have to offer it to you, and then you waive it in writing. Don't say no to that. It pays medical bills, it pays lost wages regardless of fault. But most riders will sign it away because it's just, oh, here, sign this. They don't really read what they're signing. So make sure you opt for that personal injury protection. Hospital liens, it's another thing to be aware of. Texas Property Code, Chapter 55, hospitals and counties over a certain size that provide medical services to riders in a car accident, it's a very specific and narrowly tailored statute, can file a lien on the property records of that county. And if you make a recovery from the person that hit you, you are obligated to negotiate or to pay that hospital lien. So imagine you're hit on a motorcycle, you spend 5 days in the hospital, you got $150,000 worth of medical bills. One of these hospitals treats you, you don't pay anything at the time. Maybe you have health insurance, but there's still something left over. They file a hospital lien. Then you go get this settlement, and it's $30,000, but the hospital has a lien for $100K. How do you deal with that? Your attorney will go negotiate that down with the hospital before the lien's dispersed. We're required to by law, but we have expertise in negotiating. We understand the statute, what applies, what doesn't apply. And so a good attorney will be able to fight for you and preserve that money that may come back in a settlement.
Yeah. If that at-fault driver has no insurance or not enough is the only thing standing between the rider and possible bankruptcy. And as you mentioned, it's also the coverage a lot of riders sign away without realizing it. So what is coverage in Texas? And explain a little bit more why it's the lifeline most Fort Worth bikers sign away.
UIM, commonly referred to as that, it's uninsured or underinsured motorist coverage. It covers a situation where a driver hits you and they have no insurance, or it covers a situation where a driver hits you and they don't have enough insurance, whatever that may be. And so it's something that you carry on your own policy, and it will pay when the at-fault driver, again, has no insurance or doesn't have enough insurance. And under the Texas Insurance Code, every insurer, when you go to get vehicle insurance, has to offer it to you in writing, but the rider can decline by just signing a waiver. Okay, so that's dangerous. Just like the PIP, most people don't know. It's extra, but it's also the most important. And most people just sign it and say no. And Texas allows stacking. What that means is if you have UN on multiple policies or multiple vehicles, you can add those coverages together. So let's say I opted for $30,000 of insurance on this vehicle, and then I was offered it on a second vehicle and I got it on that vehicle. If something happened, I could take those two limits and combine them and have a total of 60. So that's stacking. But the reality is in Texas, roughly 1 in 8 Texas drivers carry no insurance at all. And another large chunk of those people carry only the minimum of 30,000. So it's really not optional for a serious motorcycle rider. You need to have it. You're setting yourself up for a lot of medical bills and out of pocket if you don't pay those few dollars a month to carry that coverage. And then documentation, you should keep your deck pages and any waiver forms accessible, like counsel will need them in the first few weeks. One thing that we do also is that we check and validate that your insurance company actually offered you the UN and the PIP. If they didn't, we ask them to produce signed rejection notices, okay? We don't just take their word for it. You probably did sign it away if you don't have it, but we will demand as your attorney that they present us with the document you signed waiving that insurance. And if they don't produce it, we have forced them in this office. It has happened. We have forced them to then allot you that coverage. Not a lot of law firms or lawyers know to do that or do that. So there you go for you attorneys listening. I'll put you on some game.
And then what does the average Tarrant County motorcycle settlement look like, and what moves the number?
There's no true average. We have a running average in our office of all cases. Like you can gather data that way, but the settlement value swings so heavily based on injury severity, which is always severe, fault allocation, and then available coverage. That's kind of what it comes down to. A clean liability, brain injury case, and disputed fault and road rash case, they're not in the same universe. Like you fall down, you get road rash, but not a TBI, or you break your arm. It's very different than if you cracked your helmet and you have traumatic brain injury. So Severities really set the range there. The traumatic brain injury or the TBI, spinal cord injuries or SCI cases, they anchor really what we would consider the high end. And a lot of that is driven through future medical costs, loss of earning capacity. And then soft tissue and minor road rash cases are down at the low end. But again, it has to be documented and preserved. And a good attorney will tell you this medical documentation is not enough, and they'll evaluate your case and show you how to preserve the value. Because if you suffered a TBI, the insurance company is banking on the fact that you're not going to go get an MRI or DTI or the proper scan, and that you're not going to evaluate your concussion, or you'll just leave it at it was a headache. That's hundreds of thousands of dollars on the line. And we touched on it earlier. There's not a true average because a lot of people carry the minimum. We've had death cases where people have died on a motorcycle and the person that hit them had no assets and only carried a $30,000 policy. That case would be worth millions of dollars if there was insurance coverage, but it settles for 30,000 because that's all that's available. So the ranges swing widely.
So the injury hits, the trauma documents work the case, and the insurance map determines whether the rider walks away covered or wiped out. Next up, the evidence playbook that wins these cases at trial. So the crash report is the document the insurance company opens first. It frames the case for everyone who comes after. How does an FWPD CR3 crash report get pulled, and what does the officer's fault note do to your case?
So retrieval, FWPD CR3 reports filed with TxDOT, and it's pulled from the TxDOT crash data system, or CRIS, typically within 7 to 14 days of the crash. And then we're evaluating the officer's fault note. The responding officer usually will put codes. There's a whole code system on this sheet, and contributing factor codes are not like legally binding in court, but they will be the anchor that the insurance adjuster's opening position will be based on. Those crash records and those codes are really important. So for serious injuries and fatal crashes, the Fort Worth PD's major crash investigation unit will handle like a deeper investigation, and that report is going to carry way more weight than a standard CR3. And then us, if we're hired, the motorcycle rider, their accident reconstructionist independently will review the CR3, scene photographs, GoPro footage, witness statements, all those things. And then disagreements with the officer's fault note become the trial's central question. So we can put an officer on stand and ask him, but they've seen so many accidents that they're going to rely on what they wrote in the report. Sometimes you can get reports corrected, but that's how the officer's fault note really impacts the case.
Then let's say that the rider can move and the bike is upright. That first minute after a crash is the most evidence-rich window of the entire case. So what scene evidence wins a Texas motorcycle case in the first 60 seconds?
Everybody is an amateur photographer these days, and if the fight or flight hasn't taken over and you can gather your wits and you're in a safe place, in the first 60 seconds, a 7-shot photo sequence, the 4 corners of the bike showing the final position relative to the lane lines, both vehicles' damage zones, where was the impact, where were the vehicles damaged, the at-fault driver's license plate, and then the rider's injuries before treatment. We've unfortunately had clients bleeding out on the street that were still able to pull their phone out, make a phone call, and document some of that. Marked lane discipline as well. Photographs that establish that the bike was centered and a marked lane neutralized, like in that future lane splitting allegation under Texas Transportation Code 545.060. And then if you were wearing GoPro and helmet cam, scene photographs plus the GoPro and helmet cam footage from the rider's own camera before, during, and after impacts, the highest value evidence in any motorcycle case. So the SD card needs to be preserved if it wasn't damaged. If the camera itself or the SD card was damaged, mitigating any further damage so that we can see if we can get a tech expert to download that data. And then importantly, sometimes good old-fashioned witnesses. GoPros, they're not going to capture every angle, but you may have a really reliable good witness, so we need witness names. It could be a driver, it could be a pedestrian, name, phone number, anything before the Fort Worth PD gets there. And if you do have something that's recording, maybe a quick ask them, what did you see happen? Sometimes cops will develop situational bias. They try to be objective, but maybe they're not having a good day, and maybe somebody is rambling and reminds them of their cousin that they don't like, and so suddenly they don't hear it the same way. So it's good to try to get some of those statements before. Insurance information is a must. The at-fault driver's policy, take a photograph of that, not transcribed. Like, you try to write it down, every digit matters. And then don't discuss fault. Don't apologize. People have a tendency to say, I'm sorry. Don't speculate about lane position. Don't talk about what happened. Don't even discuss your helmet status if you were wearing one. Anything you say at the scene really becomes evidence.
Voir dire is the single most important hour of any Tarrant County motorcycle trial. The case is half won or half lost before the first witness takes the stand. How does voir dire shift a Tarrant County motorcycle trial given the documented rider bias problem?
Yeah, so this is equal parts art and science. I'm a firm believer that cases are won and lost in voir dire. So you got to do a good job of bringing the bias to the surface. And so that means asking each prospective juror directly about motorcycle riding, riders in the family, the bikers ask for it stereotype. The answers will identify biased jurors. And then what we would do in that scenario is we would strike jurors for cause. Jurors who voice a rider biased can often be struck for cause. And then that way we can preserve what we call preemptory strikes for marginal cases. Those are allotted. Everybody has a certain number of those strikes. And so we want to save them. So if we can elicit this bias and bring it to the surface, we can strike those folks for cause. And then pretrial education, you are educating the potential jury pool before you're even selecting them. So motorcycle visibility, conspicuity, that narrative gets introduced in voir dire and the opening. So the jury is going to hear it before the defense even starts talking about they were wearing a helmet or they weren't wearing a helmet. And so the reality in Tarrant County is that the Tarrant County District Court jurors lean conservative on personal responsibility. It's just where we live. And so the rider's responsibility narrative has to be re-anchored on the at-fault driver's failure to look. It has to. And if you don't have a well-versed attorney who's aware of these things and that's looking and that's counteracting all from before the trial, when you're investigating, to voir dire, to trial, then you're going to have a problem. And so then the verdict math. So we've talked about it on here. Every Texas proportionate responsibility percentage gets assigned to the rider and how the outcome is. So pretrial voir dire starts the shifting point. And again, if they say the rider's 30% at fault and they award $100,000, you're subtracting $30,000 out of that 100. You're only walking with 70, and maybe your damages are 120,000. So it's really important.
There is one phrase that lights up the insurance companies blame the rider playbook every single time. What is the worst thing a Fort Worth rider can say to the insurance adjuster in the first 48 hours?
One word, anything. Saying anything. Don't talk. Decline the recorded statement. Under Texas law, the rider has no obligation to give the at-fault driver's insurer a recorded statement in the first 48 hours. And so the I phrase trap, the insurance adjuster listens for any phrase that puts the rider in motion. So if you say, for example, I came around the corner, or I was going about, and then uses it to allege speed, lane position, and recklessness. So any I statements they're going to hone in on. And then the helmet question, like any answer to the helmet question, even an accurate one, becomes the seed of the helmet defense and damage reduction. And then the lane position question, I know we've talked about that a few times. Any answer that doesn't establish mark lane positions becomes the first seed of the lane splitting allegation. They love to do that to motorcycles. Again, the only sentence the rider needs in the first 48 hours really is all communications go through my attorney. And then say nothing else. Even if you don't have an attorney yet, you have the right to one. That's not criminal, so the stakes don't feel as high, and you almost feel like a natural tendency to want to prove your case to them. Don't do it. Have your attorney help you.
So voir dire breaks the bias, scene evidence freezes the truth in place, the 48-hour discipline keeps the case alive. For a Fort Worth rider listening right now who has just been in a motorcycle accident, what is the one thing you want them to remember?
I want them to remember they have no obligation to speak, but more than anything, call your attorney first. Our initial consultation is free, and we provide and we preserve value. So the one thing to remember is you don't have to do it alone.
If you have been in a Fort Worth motorcycle accident and you are not sure what to do next, make that call. You can reach 1-800-THE-WOLF accident attorneys at 1-800-THEWOLF.com or by phone at 1-800-THE-WOLF, 1-800-843-9653. The first consultation is free. The firm advances every cost on the case, and the fee is contingent on recovery. Thank you for watching, and we will see you on the next episode of Fort Worth Accident Attorney in Law with Aaron Siddique.